This is Daniela Ellerbeck, Legal Advisor to 4SA. Today I want to talk to you about the hate speech bill, which ironically is reminiscent of the draconian apartheid legislation, which saw the state censor speech and jail people. Specifically, I want to highlight how the current version of the bill in front of Parliament will make it easier for you to be criminally prosecuted and jailed for up to 3 years than for a court to order you to apologise or pay a fine. Now, in 2021, the Constitutional Court gave a very important decision on hate speech in South Africa in the case of John Kwelani. This was a civil, not a criminal case, brought under the Promotion of Equality and Prevention of Unfair Discrimination Act, commonly known as PEPUDA or the Equality Act. Now, the Concord used this opportunity to set the record straight on what hate speech was for purposes of the Equality Act, a civil law. Specifically, it struck down the Act's definition of hate speech for being too wide, even for a civil law. Now, under the Equality Act, a court only has the power to impose civil remedies, such as a fine or an order to apologise, or a wide variety of other creative orders against an offender. However, a court does not have the power to send you to jail and you will not get a criminal record. In other words, hate speech in terms of the Equality Act is not a crime. Now, the hate speech bill proposes making hate speech a crime. A major concern is that its proposed definition of hate speech is much wider than the Concord's definition for hate speech in a civil matter. It will therefore be easier for you to be found guilty of the crime of hate speech and go to jail under the bill than to be ordered to apologise or pay a fine under the Equality Act. This is completely topsy-turvy in law, as the standard for criminal matters is supposed to be higher and more difficult to meet than in civil. Simply put, it should be easier for someone to prove that you need to apologise than for the state to prove that you need to go to jail. Now, essentially, the bill takes the Equality Act civil standard, widens it, and then criminalises it. To explain, the bill defines harm much wider than the Equality Act, specifically defining it so that it includes any emotional harm, as well as other vague forms of harm such as social or cultural. It also fails to adhere to international recommendations that would, for example, require a direct causal link between the speech and the harm suffered. In other words, it is not even necessary for someone to prove that your words cause them any, example, emotional harm. Now, for the lawyers, in Kwelani, the Concord did say that for purposes of PEPUDA, it is unnecessary to prove a causal link between the statement and the actual harm suffered. But in the creation of a crime, the threshold needs to be higher. This is especially concerning given that the bill also criminalises the distribution and display of hate speech. In other words, think social media, while providing only narrow grounds for exemption that don't seem to provide strong enough protection for artists, academics, journalists, or religious people. The bill is not currently open for public comments. It is being considered by Parliament. Now, 4SA will continue to monitor the process and keep you up to date as it develops. Please go to the 4sa.org.za website and support us financially so we can continue to fight for faith and freedom and protect you and your organization. Thank you. Good day. This is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.